This panel is on the future of global class actions. My name is Steve Cirami, and I have the privilege of chairing this panel with a terrific group of panelists. We've got JP on stage, Arthur Bryant, and Gordon Cooney. My background has been in the class action business my entire career. I've worn many different hats, including as a class action attorney, as a claims administrator, as a court-appointed expert, and as well as a special master. And now I lead Broadridge's class action business, where we represent hundreds of institutional investors in securities and antitrust class actions around the world. As I mentioned, we've got a great panel. We're going to touch on 3 macro topics, as well as a variety of others. So please feel free to ask questions throughout the panel, and we will address them throughout, as well as save some time at the end. First, we have Gordon Cooney. Gordon's a partner and the global litigation practice leader at Morgan, Lewis & Bockius, where he concentrates his practice in class actions and crisis management defense. Gordon has represented pharmaceutical, consumer products, automotive, and financial service companies in various types of class actions. Gordon's going to talk a bit about the growing trends around the world, including the intersection of social issues around ESG. Next, we have Arthur Bryant. Arthur is with the law firm Bailey & Glasser, and he's the former chairman and executive director of Public Justice, a national public interest law firm in the US dedicated to preserving and advancing access to justice for all. He's won major victories and established new precedents in several areas of the law, including class actions, constitutional law, civil rights, consumer protection, and mass torts. In fact, the National Law Journal has twice named him one of the 100 most influential attorneys in America. Since Arthur has spent his career litigating class actions in the US, as well as objecting to unfair settlements, he's going to talk a bit about lessons learned and how he believes the class action mechanism can and should be used globally to right mass wrongs. And finally, we have JP Carroll. JP is responsible for FinTech strategy at a global payments company called Blackhawk Network. JP joined Blackhawk through an acquisition about 6 years ago, where he implemented a thesis he developed while at business school in Madrid, Spain. Entitled Digitizing Payments in the Class Action Space, over the past 3 years, JP and Blackhawk have issued hundreds of millions of dollars across over 50 class actions. As class actions and mass litigation take on a larger presence around the world, ultimately, there'll be many practical implications around getting money from resolved lawsuits. And you heard some of that on our last panel before lunch. JP is going to talk about how technology can assist in getting the money in the hands of the injured class members. With that backdrop and introduction, Gordon, will you kick us off?
Thanks very much, Steve, and good afternoon, everybody. I don't think I'm going out on a limb to say that we're seeing a really significant increase in the momentum towards class action, collective action, representative action, or group litigation throughout the world. I think there are really 3 principal factors that are driving that momentum. The first is new laws or directives either permitting these claims or expanding the type of claims that could be considered as eligible for such actions. Secondly, though, judicial decisions interpreting the existing procedural or substantive laws that favor class action. We talked at this program last year a fair amount about the UK Supreme Court decision in the MasterCard case. I think that signaled a significant willingness on the part of the UK Supreme Court to entertain class actions. It was interesting as a US litigator to read that decision because in many respects, I think it reflected an approach towards class action litigation that was present in the United States before the United States Supreme Court started cutting back on class actions in the Walmart versus Dukes case. But in any event,
Looks like we've got our first technology glitch, at least for this panel. I think we lost Gordon. Hopefully he'll dial back in. Arthur, why don't we switch over to you while we wait for Gordon to reconnect?
Okay. I hope this is not a curse that will affect each one of the speakers. Good afternoon,
My
everybody.
Especially me.
Oh, Gordon, are you back?
I'm back. My apologies. I got bumped off somehow. But in any event, I think the second factor that I identified is in the UK Supreme the MasterCard case, I think class actions, at least in the antitrust context, and a willingness to be flexible with regard to the substantive law to accommodate class actions. I'm going to come back to this in a minute. I think the UK Supreme Court decision in the Google case, it'll be interesting to see how the courts in the UK navigate some of the tensions that may exist between the MasterCard decision on the one hand and the Google case on the other hand. But in any event, I think the second factor that's fueling growth are favorable decisions like the decision in the MasterCard case. And then the third factor, and Steve mentioned this, is really the emergence of legal theories and social concerns that plaintiffs would find attractive for class or collective litigation. And so in addition to the traditional areas of antitrust or securities, evolving into employment and privacy, we are seeing class or collective litigation to pursue ESG claims. I know there is another panel, the next panel, I believe, my partner Molly Lane and other panel members are going to do a deeper dive into ESG issues. But just a couple of recent examples, I think, demonstrate the point. You have the Okapi versus Royal Dutch Shell PLC decision. That's a decision by the UK Supreme Court in the area of human rights issues occurring at the Nigerian subsidiary of Royal Dutch Shell PLC. And in that case, the UK Supreme Court reversed the lower court order dismissing the representative action claims against the UK parent for failure to exercise control over those issues. The class issue has not been resolved, but the case is at least proceeding past the initial stages. You also have such things as the mass action in the Netherlands brought by the Urgenda Foundation and 886 Dutch citizens to force the Dutch government to take further action to fight climate change. And in many of these cases, the relief sought is not damages, it's declaratory relief or injunctive relief. The relief has broad and sweeping impact, but doesn't present many of the complexities of ascertaining or allocating damages for a class. And actually, if you look at the Google decision, what the Google case did was to decline certification with respect to the damages question, but to note that the issue of liability in that privacy case was appropriate for class certification. And so that case may raise some questions as to whether, for example, funders will get deeply involved if you can't get a damage award as part of the class proceeding. That's an issue for another day. But you may have other organizations besides the classic litigation funders who will want to get behind class or group litigation to try to drive some broad societal change where the relief being sought is declaratory relief or injunctive relief. And so I think for all three of those reasons, the expansion of laws, favorable decisions interpreting those laws, and I think the rise of this ESG movement, we're going to see continued forward progress and momentum towards embracing class litigation throughout the world.
That's great. Thanks, Gordon. Before we move on to Arthur, I'm wondering what your thoughts are around the recent Google case that you were talking about. Specifically, if you can't have damages, does that mean it's going to move more towards a mass tort-like regime in the U.S. and an MDL, or what are your thoughts on that?
Well, that's a great question. I think clearly what the court has said is, at least in that case, there are too many significant differences in terms of whether people were actually injured, the amount of damage people may have suffered in that privacy case. And so the court wasn't willing to extend the certification to include the damages question, but concluded that liability could be determined. In the US, that would be the resolution, for example, of an issue class. And so I think we're going to have questions in the UK about whether issue classes will be permitted. I think the open question, Steve, number one, is what would happen with the class action after a liability determination on a class-wide basis? Would there be bellwether trials with regard to the amount of damages that different types of plaintiffs may suffer? What's the relationship between the liability determination and how one could get to some kind of a class-wide damage calculation? And what value in maybe later litigation would the liability determination on a class-wide basis be? I think we're going to see all kinds of creative approaches by plaintiffs to take that liability determination and figure out how you could work up to some kind of a damage determination, either through negotiation or through bellwethers. And on the defense side, I think you're going to see a willingness on the part of the defendants to hunker down and say, no, there may be a liability determination, but we've got to go through many different adjudications as to damages. So I think the Google case is very interesting. I think it remains to be seen in later litigation. I think plaintiffs will try to say their cases are more like MasterCard and less like Google. The defense will say, at least on the damages question, that their case is more like Google and less like MasterCard. And then we'll have a whole wave of proceedings and I think creativity both on the plaintiff side and the defense side in those instances where a class may be certified for liability purposes. And then the question is, what happens next?
Great. I actually have a few follow-up questions, but I'm going to save them for after because I think this is a terrific segue to what Arthur's going to talk about. On the last panel, we heard a lot from Cam and Steve and others about how there's an opportunity really to improve the process and create more efficiencies. And so Arthur's going to talk a little bit about that, lessons learned from his practice throughout his career in the U.S. Arthur.
Thanks, Steve. Having practiced law as a public interest litigator and focused on the public good for basically my entire career, from my perspective, when we look at this, we are really at an extraordinary moment in the development of class actions, particularly globally. To begin with, class actions are the single best procedural device we have yet created to resolve claims and provide justice when large numbers of people are allegedly injured by a product or a common course of conduct. What U.S. history has shown with class actions is that properly used, they are an enormously powerful tool for ensuring that the law is enforced, that wrongdoers are held accountable, the injured receive relief, illegal conduct is deterred or stopped, and justice can be done. But what U.S. history has also shown us is that abused, class actions can be an enormously powerful tool for ensuring that the law is not and cannot be enforced, that wrongdoers are not held accountable, that the injured lose their rights, illegal conduct continues, and injustice prevails. Part of the problem with the EU and other countries figuring out what they wanted to do about class actions was these abuses, which often were seen as a fundamental part of American class actions. I have spoken in Geneva about, and I've been on several panels about this, and it seemed that in the EU, US class actions were perceived more in light of their abuses than their accomplishments. But regardless, the growth of them is inevitable. Now, Gordon gave several reasons why he thought they were inevitable. I agree with him, but I think there's a more fundamental reason, and that is that mass commerce is growing and spreading. More and more people in more and more places are being affected by the same products and a common course of conduct. When wrongdoing is done, it affects them all. There are lots of examples throughout the world. The most obvious one that everybody's familiar with and that really drove a lot of these changes, in my view, is Volkswagen. Volkswagen emissions litigation. When those in Europe and in England saw what happened with US class actions not being abused, but instead being used properly to hold Volkswagen accountable and how much Volkswagen had to pay the people that cheated in America, there was a huge push to expand this device action. So the growth of class actions is, in my view, inevitable, but so is resistance to class actions because mass wrongdoers don't want to be held accountable. That's common sense, we understand it, and because they will both benefit from abuses of class actions and use those abuses to try to limit or eliminate class actions. That is what has been going on in the US for the last 10 to 15 years, particularly with the support of members of the US Supreme Court. These two facts, the fact that class actions are inevitable and that resistance to them is inevitable, have put us at an extraordinary moment in US history. In fact, in global history. In America, the US Supreme Court, which actually a law review article done, not that long ago by then alive Judge Posner in the Seventh Circuit and two law professors, documented that before Trump had made his appointment, it was already the most pro-business, anti-consumer Supreme Court in US history. And it has gotten more that way since. This US Supreme Court is changing the law to limit class actions and allow corporations to eliminate them in many, many areas, especially through mandatory arbitration clauses with class action bans. Gordon mentioned Walmart. Walmart was nothing compared to American Express and Italian Colors and the Concepcion decision, which has basically allowed many corporations in America to eliminate consumer class actions and employee class actions. So at the same time, class actions are being cut back in America, where they were born. In England, the EU, and many other countries, governments and the courts are increasing the use of class actions, as the EU directive, UK's Supreme Court decision in the MasterCard case demonstrates. If you wanted to sort of do a compare and contrast, all you needed to do was to compare that decision with American Express versus Italian Colors in the US Supreme Court. There, it was an antitrust case. Italian Colors is a local restaurant. It's actually near where I live, although I had nothing to do with the lawsuit. And Italian Colors alleged that American Express was using its market control of the premium credit card market to basically require all small businesses in America to pay excessive prices to process any other credit card. The allegations, when they were added up, and you might think, well, wait, how realistic is this? Allegations, when added up, were $16 billion. That's a B. And if you think, well, wow, that's astonishing. In fact, a similar case had been brought against MasterCard and Visa and settled for over $6 billion. The company paid. But American Express was able to get the US Supreme Court to say, oh, because of a class action ban in a mandatory arbitration clause, even if we did everything it's alleged we did, we get to walk away with the entire $16 billion amount. If you compare that case with what happened in the MasterCard case in the UK, you get a sense of where the courts are and where England in particular is compared to the US. If class actions are going to expand globally, and they are, it is critical that the global community understand what America's experience has taught us to ensure that class actions can and do achieve their critical goals. Now, I'm happy to discuss details with all of you, but for the few minutes I have here, let me just highlight a few key points. We need to try to make sure that, to the extent possible, the procedures and the financial options are designed so, first, class or collective actions can be brought when a large number of people are allegedly injured by the same product or a common course of conduct. It is increasingly true in America that they cannot be brought, especially because of arbitration clauses and class action rights. Second, we need, to the extent possible, the procedures and financial options need to be designed so class actions are especially available when people have allegedly been injured in amounts or ways that they could not afford to seek or obtain relief individually. In the MasterCard case, the Supreme Court of Great Britain was very sensitive to this fact and said the comparison should be, what's the chance that people could get relief without the class action? In the US recently, it has almost seemed like the fact that people can't get any relief if we don't have a class action is a reason too many courts will not certify. Let's just get rid of them entirely. Where in England, the court emphasized, no, that's a critical reason that we need to have class actions. Now that should be and has been the law in the US, but it's been moving in the wrong direction for a time now. Third, we need to make sure that when class actions are successful, they actually get the relief sought, whether it's the money sought, injunctive relief, or both, to the people who were injured. One of the major criticisms and problems with class actions in the US is too often they do not get the relief sought to the people injured. And that leads to the fourth thing I would just emphasize for the moment, is that the attorney's fees or the return to the funders in Europe or in the EU or in England need to be based on how successful the case is at getting the relief to those people. If the incentives are lined up properly, so the class action attorneys or the funders' recovery depends on their ability to get the relief to the people they're trying to get the relief to, it dramatically increases the likelihood of success of those cases. And I think those are key lessons we've learned in America that I hope the design of the system and the procedures in the EU and in England will take into account in planning this procedures.
Thanks, Arthur. I've got a few follow-up questions for you, but I'm going to save them till after JP goes. You gave us a great segue when you talked about relief, making sure we get relief to the class. And that's what JP and his company have been focused on. And these issues are going to come up in terms of getting relief to the class when you're talking about cross-border litigation. So terrific segue. JP, I know you're waiting patiently on the stage. Why don't you take over?
Sure, yeah. So the payments piece, the last mile of the class action settlement is key to providing justice, but not only that, ensuring that class actions work and they work for all the harmed individuals. So in terms of the future of global class actions, we can kind of paint the picture based on best practices that we've taken from the United States and extend it into the global setting. So as class actions and mass actions occur, we really ask two questions and need to ask two questions. The first one is, do those dollars need to get to consumers, to claimants, to individuals? And if the answer is yes, then it's a class action. And the second question is how? And so that's really where there's a few general themes that we've found in the United States that are kind of best practices that we can take forward and guide for class action payouts and distributions in Europe, in the UK, and globally. The first theme is this idea of choice. Consumers want choice, and the best and most efficient way to deliver choice is digitally. So the first, component of strategizing a payout for a class action is coming up with several options that you can provide as choice to the consumer, to the claimant, and those choices should ideally be digital. What we found is the sweet spot for number of choices that you can provide to a class member is around 5. Any more than 5, and you're going to start to overwhelm them with too many options, and you might have dropouts. There might be attrition with the overall process, which you don't want. So you want to keep it simple, but you do want to provide those 5 options. So, in the United States, those 5 options are going to be different than the UK. They're going to be different than the EU, and so on. So it's important to look at this as a jurisdiction by jurisdiction basis. As a matter of fact, I was looking at this legal guide. I think a good addition to it would be a country by country breakdown of popular consumer preference payment options on a country by country basis. But needless to say, so you want to give them those 3 to 5 options. I did a quick search for UK options, preferences for payments, and the top ones were for the UK is Visa and MasterCard, digital wallets like PayPal, cash, which we're going to omit because it's not a feasible option for distribution, and then bank transfer. So those 3 payment options should be the ones that you offer the benefit through to class members. So we would work with an administrator. You would want to work with your administrator to get those options delivered via email, and you would effectively send an email, provide those options being a virtual MasterCard, virtual Visa card, PayPal, push, or bank transfer, and let the consumer decide where they want their benefit dollars, pounds, what have you, to go to. Now, another theme as it relates to that is the type of option needs to be universal, and it should encompass options that are both require sensitive data and do not require sensitive data. For example, a bank transfer requires a user to put in their banking details so that you can pay the user to their bank account. Not all consumers, claimants, are going to want to provide that information. So it's important that in addition to that option, which you ought to include, you also include a more universal option like a virtual MasterCard that doesn't require someone to provide secure or private details, or PayPal that just requires an email. So having a mix of options that require and do not require sensitive details is important for user experience, as well as adhering to whatever the GDPR requirements might be in a given country. A third theme, and there's many themes, but I'll just keep it at 3, is the payment related reporting. So when you offer a digital payment solution with choice, a benefit of doing that is being able to provide reporting, and reporting is key to all parties. One, to an administrator, to a plaintiff, to the courts and the judge, just to ensure that there was take rate. You can also provide reporting in terms of acceptability if the payment went through or did not go through. The overall goal is to ensure that the funds get to the claimant in the most efficient means possible. So when you have this reporting, you can justify and you can effectively audit and prove that success rate. And that's possible in a digital world. It's not always possible with a paper check world, which I know is more tied to the United States. But that reporting component is key, and in a sense, the future of global class actions is this digital distribution means where you're showing everybody how successful you are in getting payments to the end user. So I'll stop there and turn it back to you, Steve.
Sure, thanks. Actually, I've got a follow-up for you. Arthur talked about how one of the reasons why we're seeing the growth of class actions is because of mass commerce and cross-border commerce. I'm wondering how your firm have thought about FX issues. we might start seeing settlements that with folks across many jurisdictions. You could have a settlement involving folks from Europe, and it implicates the euro, from UK that implicates the pounds, in the US for the dollars, and then in Canada you'd have 4 different currencies right there. How can sort of digital payments tackle that problem?
That's a great question, and I'd say seamlessly, in so much that when you're offering a digital solution, and the administrator or whoever's collecting the information knows which country the individual is residing in, you can send those options in such a way that it's dependent on the country. So you can do this easier in the digital world than the physical world, but you can provide 5 different options to the American claimant compared to the 3 options in the UK and the 4 options in Europe. And then the other option is to provide the likes of a virtual card solution that provides that currency exchange behind the scenes. So it's effectively a universal payment product that you can issue in one currency that can be redeemed in different countries in different tenders.
That's great, thanks. Arthur, follow-up question for you. You I think this is a quote, you said that the class action process is the single best procedural device created to deal with mass wrongs. And I personally agree with that and have throughout my career. I'm wondering if you have any thoughts on why it took so long to really become more of a global phenomenon. I really expected personally a significant uptick after Morrison, which was in 2010. It was a pretty quiet decade, and now you're starting to see this real explosion. What are your thoughts around that?
Well, I'm not 100% sure, obviously, but what I was struck by it was I was asked to come speak at The Hague, I'm going to say 10 years ago, about whether the EU should adopt class actions and the controversy around them. And I will say I was sort of, as I referred to in my earlier remarks, I was sort of stunned to discover the perception of class actions that existed here or in the EU compared to perception of class actions in America, which is, in America, they're this powerful tool for doing justice, but abused they can do wrong. Of course, the effort of the companies that were being held accountable was and has been to portray them the opposite. That basically they are a tool that makes class action lawyers rich and brings no justice to the people. And we need to stop them, not help spread them. And I think that sort of propaganda had been enormously effective in Europe and England. When I got over there, it was the lead line I kept hearing from everybody was, well, yes, we want some sort of collective action, but not a US class action. And I would say, well, wait a minute, why not a US class action? And what I would get back is what I had just heard was, oh, well, the US class actions, the way we perceive them is that they don't really get relief to the people. And of course, if that's what you think they do, you're not going to spread them. But then when an event came along like VW, where people couldn't help but see how they really work, at least when they're properly used, I think it helps spur the spread a great deal. And as people go along thinking, oh, well, there aren't that many mass wrongs, or companies aren't that dishonest, or they could be trusted, there's less pressure. But when not only is there mass commerce, but there's mass wrongdoing in commerce, and big companies are cheating lots and lots of people out of lots and lots of money, and clearly willing to act unethically to add to their bottom lines, as happened in VW, I think it dramatically increases the desire to spread them.
I was muted. Thank you, Arthur. I've got other questions for all of our panelists, but we've got about 7 or 8 minutes left. So maybe we can open up to the audience, either virtually, and Rachel can read the questions out, or JP, maybe you can facilitate if we've got questions with folks in person.
Sure.
There's no questions.
All right, then I'll go back to mine if we have none out there with the audience. You talked a bit, or just now, Arthur, about sort of the perceived abuses, and we know that that's in the news from time to time, and in the U.S., judges have the ability under Rule 23 to handle that. One of the ways I think we're starting to see Europe sort of deal with what they perceive as the abuses is through what's called a foundation-led, class action or collective action. Really, this started under Dutch law, and it was called a foundation or a stitching. You saw that in a variety of large class actions, which resulted in settlements under Dutch law. But the EU directive also talks about that, using some kind of foundation or group that oversees and brings the litigation, as opposed to directly by the plaintiff's lawyers. I'm wondering what your views are on that as a way of handling some of the perceived abuses, or if it's just, or otherwise how you think it's going to impact massively.
I think it's going to be fascinating. I think it could make a major difference. But another piece that ties into it is the difference between the US not having a loser pays rule and the US basically having contingent fees. So the plaintiffs' law firms end up for the ones having to be the primary financing agent for class actions. And the way it's being set up in EU and in England, where there's a loser pays rule, where the money is not going to be coming from the firms for the plaintiffs' firms primarily. It's coming from funders and these independent bodies having to be the plaintiffs. I can imagine, you can all sort of imagine ways in which such organizations could be great and could really exercise influence. There are all sorts of public interest groups in America that do the same thing, from the National Consumer Law Center to Public Citizen to Public Justice, et cetera, can do these sorts of things. But then you can also imagine all sorts of, for lack of a better phrase, sort of shell organizations, really under the control of somebody else, really designed for purposes that aren't really in the class's interest. And I think we have to be wary of all of that. I will say one other thing in terms of the whole development in EU and England. I think what people need to be aware of is an attempt every step of the way, as the procedures are being designed by companies who will likely be the defendants in these cases, to make sure the procedures are such that they can't be used effectively. Basically try to gum up the works procedurally. That's what's happening here in America at the back, call more of a back end, because class actions were working effectively. But now that the companies see how they can work, you're seeing all sorts of ways to change the rules coming from the US Supreme Court on down to make it marginally harder to do it. And each one of these marginally harder things to do it means companies keep more money and the consumers end up paying more money.
One thing I would like to address a little bit of that, though, because I think, I think in the U.S., one of the touchstones I think that has gotten greater traction has been something called the Rules Enabling Act. And what the Rules Enabling Act in the United States says is that you can't use one of the procedural rules to change the substantive law. And so, certainly there are instances where defendants are simply trying to gum the works, but there are many instances where what the defendants are simply saying is, wait a minute, I'm entitled to have the law applied, not to have the law changed to permit a class action. And if the law is faithfully applied, a class action is simply not efficient. And so I think a lot of the action in the United States has been around those issues. I think the tension between permitting, allowing, and facilitating a process of a collective action on the one hand, so that appropriate cases can be brought as a class, while at the same time not changing the law. Simply to permit a class action and override the defenses that a defendant would legitimately have. I think a lot of the tension is in that space. I agree with much of what Arthur has said, but there clearly have been abuses, and there are cases where it's simply not appropriate to certify a class, and changing the law substantively to let people bring claims. I think defendants have a legitimate interest in saying, wait a minute, the law substantively shouldn't be changed just to permit a class action.
Thanks. I appreciate you jumping in. I was going to ask, wanted to hear your perspective on that same question. Relatedly, Arthur talked a bit about changes from the Supreme Court in the United States to pull back class actions, and you're seeing more mandatory arbitration clauses. I'm wondering your views on that issue, Gordon.
Well, we certainly have seen a number of companies that have put in place these mandatory arbitration clauses, and they have cut back on the amount of class actions we've seen. But what we have also seen is plaintiffs filing mass arbitrations in the United States. Under the Supreme Court standard, the arbitration procedures, in order to be enforceable, need to be, for lack of a better description, reasonably pro-consumer. And so many of the companies that put in place mandatory arbitration provisions with class action waivers did so in a way that made it very easy and inexpensive for plaintiffs to bring the arbitration, and impose significant transactional expense on the defendant's side. And so you've seen a couple of examples recently of, I think, plaintiffs' groups filing mass arbitrations and effectively getting to a somewhat similar outcome. And so I do think there's no question that the mandatory arbitration clauses with class action waivers have cut down certain kinds of class actions, but we're seeing a reaction to that in the form of mass arbitration.
Yeah, I've heard the same thing. I was hoping you'd touch on that, so that's very helpful insight. We're pretty much out of time. I think we've got about 30 seconds left or so. Just wondering if we've got any questions from the audience in person or virtually before we wrap it up. All right, well, thanks, Rachel, and back to you, Florian.